Well, hello, friends. Welcome to Investment Immigration Conversations. I'm Carolyn Lee, principal and founder of Carolyn Lee, Pllc, a U.S. investment immigration law firm dedicated to helping clients build their future with investment immigration. Well, today is very exciting because we are launching a new series, Pitfalls and Dangers to Avoid in EB-5. We usually like to cover the latest news, important stuff that we in the EB-5 ecosystem ought to know. And we go into various depths of important issues in our day. But we don't usually cover, at least directly heads on, this is stuff we want to steer clear of. But it occurred to me that this is an important side of the equation of better understanding the system in which we operate. And so in that spirit, we launched this series. And today we're covering project structuring pitfalls to avoid. And this is a nod to the upcoming 15th annual IIUSA gathering in Houston at the end of this month, starting April 28th. I'll be moderating a panel on USCIS adjudication trends. So hope to see many of you there. All right, let's just get right into this. We have a handful of pitfalls to avoid on the project structuring front with you. I hope this will be helpful. TEAs. Let's talk TEAs. Obviously, fundamental, because if we get the TEA wrong, we're looking at RFEs and NOIDs that say, oops, it's your investments are not at the 800,000 level, it's at 1.05. And I have seen such NOIDs, and it's a disaster. So we want to avoid that. And we go to the definition of these TEAs, rural area and high unemployment area. So let's look at the definition of rural area. So important because rural area projects have 20% of the 32% in the set-asides. A rural area, it's a geography. It's an area outside a metropolitan statistical area and also outside a city or town having a population of 20,000 or more. Okay, so the area, a rural area is a residual area. It's an area that's not in an MSA and also not in a town or city with a population of 20,000 or more, whether that city or town is in an MSA or outside an MSA. So it's all that area that's not in those two kinds of areas. It's a rural area. So to prove up that an area is rural, you need to show that the area that your project is sitting in is not in an MSA and is not in a city or town with that 20,000 population. It's got to be under that threshold. How do you show that? Well, there is a list that the Office of Management and Budget, OMB, publishes with a list of metropolitan and micropolitan statistical areas. So you show we're not in here. So the OMB MSA list. And then you show the population of the particular city or town by going to the census.gov website, federal data that reports out the population of a particular city or town. So it's those two things. It is not any other kind of official letter. Years ago, reviewing a rural project by folks who, by all accounts, would know what they're doing, produce a state designation letter to show that an area is rural. And it's like, that's not it. That's what you need. It's just pre-RIA for high unemployment areas for sure, but not for rural. And it was a bit of a surprise. So definition of rural. High unemployment area. High unemployment area, of course, is about having an area having an unemployment rate of 150% or more of our annual unemployment rate. So this again is about, well, what is the appropriate geography? It is the census tract or census tracts upon which the project is sitting. So the project could be on one or more census tracts. So all of those, okay? Plus, you may count adjacent census tracts. So when this new definition of high unemployment area was first promulgated under the RIA in 2022, there was a question as to whether or not it was just one adjacent census tract that qualifies, or is it the adjacent census tracts around the areas on which the project sits that would qualify. And the answer, based on USCIS adjudication of this definition, is that the adjacent census tracts taken together with the project census tract or tracts would qualify. They just can't be strung out so that you have any census tract that does not touch or is not adjacent, to use the term in the RIA, with the census tract or census tracts on which the project sits. Okay, high unemployment area. Now, there is a time component as well to the determination. So first of all, preliminarily, the high unemployment area designations cannot be done by state official or any official other than DHS. So let's just get that out of the way. And then there is a validity period of these TEA determinations, which is 2 years. I'm talking about high unemployment area TEA determinations, 2 years from the time of the 956F filing that contains evidence of the project qualifying as a TEA. And so if a raise for a project is going on beyond the 2 years from the time the 956F is filed, and it is not unusual, then know that the validity period has expired or will expire. So you will need to get that TEA revalidated for one or more additional 2-year increments. Now, we do not have procedures or regulations or any guidance on how to do that. Whether, for example, it is required to be made on a formal 956F amendment for a hefty filing fee. And in the absence of that, we in the industry are advocating for, and some have opted to go the route, and thus far, knock on wood, no objections from adjudicators to report the TEA remains valid by way of a notice filing to USCIS email inbox. Okay, the IPO. Second danger, pitfall to avoid from a project structuring documentation standpoint, be wary the side letter. Side letters, oh my. If one crosses our desk in the course of project review, very, very careful to review the content. Now, I'm not talking about an admin fee reduction letter. With respect to those, investors have to lawfully source the base capital contribution amount and the admin fee, whatever it is. That's not the side letter I'm talking about. I'm talking about the kinds of side letters that may promise or be read to implicitly promise any kind of a return of or on capital. And this is, I would submit, a time to be particularly wary of this, because when things get uncertain, and as we get closer to 2027, when RIA sunsets, and other times of uncertainty, and we have a couple hanging over us. that's when we might see these kind of popping up in the ecosystem to give anxious investors who are understandably anxious some undue comfort. They can have no comfort with regard to whether or not their investment is at risk. And a recent example, reviewing a 956F approved project. Well, it's 956F approved, right? And I actually got questions, and not even in connection with that particular project. What are you worried about? It's 956F approved. Why are you even reviewing it? There are many reasons too. And one among those reasons is the potential revelation of items of concern. For example, things like a side letter that may promise a return of capital in the event of X, Y, or Z. Don't want that. And USCIS is aware of the play of these side letters. And so that is a surefire way to sink a project and innocent investors along with it. Right. Conditions precedent to proceeding. There's a bit of a mouthful. So if there are any conditions to the project advancing, sometimes there's an eagerness to launch a project, perhaps a little bit earlier than ideal. And then you have things that are outstanding that you need in place for the development of that project and job creation to proceed. For example, other financing sources in the capital stack. The senior loan is an N. Or permits, or sometimes land acquisition. And if any one of those things doesn't ultimately come into play, that can obviously jeopardize the project moving forward. And for sure, these are items that USCIS is looking for and may very well, I mean, you can expect at least an RFE on these points. So something to be aware of. And certainly I've advised on projects and projects have launched with not all of these conditions and ducks in a row that ideally would be the case. But knowing the risks and weighing the totality of the presentation of project eligibility, that's what this factors into. PPM immigration risks. Oh my. In the course of reading many PPMs, you just don't want to see one that talks about backlogs in Vietnam. Because you know that PPM has not been updated and the EB-5 risk factors not closely studied and revised to be reflective of current conditions, which it is required to be. So this is an area that is not only critically important, and then there are certain specific EB-5 RIA risk disclosures that are required under the statute. This is an area that I would submit to you is worth making sure that you're getting the highest quality in terms of what the actual EB-5 risk factors are of the day that you want to put in your disclosure document. Finally, for today, bridge financing. Notoriously tricky, as we've seen in USCIS adjudication over the past probably a decade. So this is an important feature of EB-5 project structuring. We need this because we can have no certainty in the success and the time frame for any EB-5 raise, correct? Yes. And so on the one hand, to the prior point made, we need to show that a project is ready to proceed. It is ready to go. We don't have big conditions precedent to this thing happening. But on the other hand, there's a tension there because, well, what if, what if the EB-5 raise doesn't, come in or not in time, or it's delayed or what have you? Well, often the NCE project developers, project sponsors are going to show that, well, we've got the early financing in place. Now, what bridge financing policy allows is, okay, so you can go ahead and start that project, and your later arriving EB-5 investors can get the job creation credit from that earlier development activity. But there has to be a connection. There has to be a nexus between that money, the later arriving EB-5 money, and the earlier money spent. How do we establish that nexus? There has to have been contemplation of a replacement of that short-term temporary financing with later arriving long-term capital. And the later arriving capital does not have to have been EB-5, which is rather generous, but it has to have been contemplated. And another tricky part, but the logic is there, that initial financing, the bridge financing, has to be short-term, right? Because this longer-term capital is coming in to replace it. Now, the duration of that short-term bridge is also undefined, kind of adding to the bit of fog in this essential feature of EB-5 project structuring. However, it's something that we need to be mindful of. Again, the way that we think about this is it's sort of like it's a gear, it's a series of gears that have to turn together. And where you see there's a stickiness in one part of the machine, you need to think about, how does this compensate? How are we going to get this whole to present as a feasible business plan for job creation? Let me read the policy definition of bridge financing, because the language is helpful always to come back to. So bridge financing, as critical as it is, it's not in the statute. It's not in regulations. It lives in policy. So bridge financing. A developer or principal of a new commercial enterprise, either directly or through a separate job-creating entity, may use interim, temporary, or bridge financing in the form of either debt or equity prior to the receipt of immigrant investor capital. If the project starts based on the interim or bridge financing prior to receiving immigrant investor capital and subsequently replaces that financing with immigrant investor capital, the new commercial enterprise may still receive credit for the job creation under the regulations. Generally, the replacement of temporary or bridge financing with immigrant investor capital should have been contemplated prior to acquiring the original temporary financing. However, even if the immigrant investor financing was not contemplated prior to acquiring the temporary financing, as long as the financing to be replaced was contemplated as short-term temporary financing that would subsequently be replaced by more permanent long-term financing, the infusion of immigrant investor financing could still result in the creation of and credit for new jobs. I can't tell you how many times I've charted this, with diagrams, color-coded, different kinds of flow charts to unpack this language. And it is an exercise very, very worthwhile. Bridge financing. Essentially, if I were to boil this down, the pitfall is bridge financing has to be a forethought, not an afterthought. That is what the adjudicators are looking for. Is it you're just sort of thinking, oh, EB-5, let's bring it in to the stack now. That is, that's to be avoided. The Nexus is about the contemplation early, a forethought with EB-5 to replace that early money. All right. If there are any questions, I'll stand for a couple of minutes. All right. Well, then that is all for our April edition of Investment Immigration Conversations. We'll see you next month, if not earlier. There's so much going on. Be well.